Number 103, People v. Kaval.
Good afternoon, Your Honors. Chris Blira-Kosler for the Office of Melinda Katz, the Queens County DA for Appellant. At the outset, I'd like to ask for 2 minutes of rebuttal time, Judge.
You have 2 minutes.
Thank you so much. I think there's one thing that we can all agree upon, one fact that's indisputable here, one thing that even my adversary would agree upon. Mr. Kaval is a persistent violent felony offender. We know that because that's what the facts show. That's what the complete record shows.
That's not what the facts showed to the appellate division, though. The facts showed to the appellate division that the people couldn't establish that he was a persistent violent. As a matter of fact, that finding by the appellate division was made at the behest of the Queens County District Attorney's Office, was it not?
Well, both sides had agreed to a resentencing. The problem with the decision is that it was based upon an incomplete record. The city jail time wasn't even litigated.
And that was the
on
fault
direct
of the
appeal.
people. It was the people's failure to produce the evidence to get the ruling, and then the people's concession afterwards that the defendant wasn't one. That really puts us in this position today, right?
Well, you can't really concede your way around the statute because the statutes contain mandatory language.
It's not conceding around the statute, though. There was a fact finding at the sentencing below. The people indicated that there was city time that could be used for purposes of tolling here. They were instructed by the judge to get all their ducks in a row, to have that all ready to go for the hearing, and it didn't happen. And after that, when it gets up to the appellate division, the matter is conceded. So it's not as if there wasn't it's not just a factor of an opportunity to litigate the issue. It actually was litigated.
We didn't concede, though, that he was not under any circumstances a persistent violent. And when we asked for the resentencing, we asked for it in a very broad way. We said, for example, he could perhaps be sentenced as a persistent felony offender. We never conceded under no circumstances because this never occurred.
He said he could perhaps be sentenced as a discretionary felony offender.
Right, as one example. We use that as one example. We never limited our options upon resentencing.
Did you suggest at the appellate division that it could be remanded and he could once again be found a persistent violent felony offender?
Well, that argument wasn't made, but cases are routinely remitted when there's an error below which involves the mandatory requirement to file a predicate statement or a persistent violent felony offender statement.
Let me ask you this. Suppose on the first appeal of the appellate division had remitted to Supreme Court and said, you have to resentence him as a second violent felony offender. Could the sentencing judge have sentenced him as a persistent?
Well, I think after all the facts came out, we might have moved to re-argue.
If that was the remittal, if it was, you must sentence him as a second violent offender, not a persistent. If that was the order on the first appeal,
right,
could Supreme Court have done something different?
Well, before I can get to that, though, I have to say one thing.
Sure.
If those were the facts, we would have probably moved to re-argue before the appellate division, asked the appellate division to change its remittal order.
And suppose they didn't.
Suppose they didn't allow it?
Right. They stuck to their opinion. It goes back. Can Supreme Court do something different?
I would submit no.
Okay.
I would submit no because the statute is mandatory. It doesn't say may. You know, in the last case,
I'm sorry, I don't understand the no then. You're saying that even if the appellate division had said you must sentence him as a second violent, not a persistent, Supreme Court could sentence him as a persistent.
But that's what the statute says. I mean, I
I'm
know
just
it's an anomalous result, but if a judge is
asking you whether a subsidiary court has to obey the order, if it's clear, of a superior court.
And my answer to that is that the court has its first and foremost duty to obey the legislature.
So your answer is no.
The answer is that it could go ahead. I mean, you know, it seems like a strange result. They'd be disobeying an intermediate court, but
with respect to that information, that there was time that the defendant was incarcerated, once the district attorney discovers that information prior to sentence, whether it's re-sentence or initial sentence, what is their obligation?
when we discover that information.
When you discovered the information, is it optional for you to deliver that to the court?
No, I mean, it's mandatory. It's mandatory for the court to act upon it once it has that information. You know, that's basically the import of this court's ruling in Scarborough, which was basically a reversal based upon the dissenting decision, which said that negligence, even oversight, does not change a court's duty to comply with the statute.
If, as you say, to the appellate division, you give an example that there might be an opening to create a different record, to request discretionary, right, a discretionary status.
This is now on
assignment.
appeal?
Yes, that's what I'm talking about. Yes. If you did that, and you only gave the example of the discretionary, why does that not lead us to conclude that you were not seeking
I mean,
a
again,
reopening of the record and to proceed in that way? I mean, I don't understand why you wouldn't have said, and we can get those city records.
Right, I mean, but, you know, I don't think the standard is, could we have written a better brief? I mean, maybe so.
No, but
Right.
you're being clear with the appellate division of what, you've made a concession, and now you're being clear with the appellate division of how you see this case proceeding, so that the judge below does not have any confusion about what the judge is able to do and should do.
But I mean, the concession was based upon the existing record, and the
Well,
appellate division
and
reached...
it's already been pointed out, it's a record
Right.
that you all created, and then you wanted to create a different record.
Well, I mean, if we're going to go to how the record was created, yes, we did have a duty, I will admit that, under the statute, to file
Yes.
in writing,
Yes.
not just the oral representation, but the prosecutor did orally represent that. Now, nobody took issue with that. That is deemed, that fact is, that uncontroverted fact
Did
is
you argue
deemed
that to
waived.
the appellate division?
That was not
No,
argued
you made a
to the appellate
concession, so
division.
that,
Yeah, a consent, but what did the appellate division
why did you
decide
say
too?
that the
Based-
record was good? You could have tried to argue, I don't know how you would have succeeded, but, you know, that
Right,
case
you
is not
could have
here.
tried...
Could have said,
Exactly, though, that's-
we mentioned, but why not tell the appellate, we mentioned this on remand, we're going to pursue this.
It probably would have been sent back anyway based on, I mean, look, you can make the argument based on Bouyer, any number of cases, well, there was an oral representation, but the response would have been, but you have to do it in writing, so it could have been sent back anyway. But my only point is that the concession, the words you use in a brief cannot be used to circumvent the court's
When a case
mandatory
is
duty.
sent back for resentencing, is it, do you start from scratch? Or is it simply that you just resentence him as if it were, as it's argued here, based on what was presented to the appellate division?
Well, I mean, a resentencing by definition is a de novo proceeding. That's why the court could consider the additional evidence of Mr. Kaval's rehabilitation and actually sentence him to 20 to life instead of 23 to life.
So
But
that
applies-
gets me back to Judge Wilson's question, that answer. Why couldn't the appellate division have said, resentence him as a discretionary second?
A discretionary second felony offender?
Yes.
Okay, so I mean,
And that wouldn't be de novo, that would be a tightly directed resentencing hearing.
okay, but that still would have been in contravention of the facts that came before the resentencing court. So I guess the resentencing court could be seen to be in a bit of a dilemma. You have a remittal order from the appellate division, and under Judge Wilson's scenario, they refuse to change the remittal order, but still, you have the statute. So yes, you have to obey the
Well,
words of an
didn't this-
appellate court, but the words of a statute, I
Yeah,
think,
but the
would come
record
before
would have
that.
been the same. You're still arguing that you had, that under the law, you have the opportunity to come and create a different record.
I'm sorry, can you say that again, Judge?
I'm sorry. As I understand your argument is that under the law, you are able to create another record, not the one that you didn't succeed on at the first appeal. Am I misunderstanding your position?
I think my position...
Because otherwise, the judge just has the record that went before, and you had conceded that on that record.
My
it was a basis of
basic...
valid.
Sorry?
Go ahead. No. finish.
No, I mean, our basic overarching position is that this is not a law of the case. This is the court has to follow the statute
Well, my
case.
question is
Okay,
not really directed at the law of the case. I mean, what you're proposing really is that if a lower court disagrees with a clear order from a superior court, it can turn to the statute and evaluate the statute for itself, regardless of what the superior court says. And I'd be surprised if anybody on this bench thinks that.
I mean, I know that's a strange result, but it's not really evaluating the statute because there's nothing to evaluate. The statute says must. If information comes before, what's the court supposed to do then? Just ignore the fact that somebody's a
No.
persistent?
Doesn't our legal system allow for a challenge to that order from the appellate division?
Well,
Isn't that your opening? That the
We could always seek
mistake is
leave,
not with the
correct?
judge who does or doesn't follow, the mistake is, in your view, from your view, at the appellate division.
I mean, we
And
could
that's what
seek
you need
leave
to
to appeal
challenge.
based on the remedy, I guess. That's a discretionary determination. We don't get that as a matter of law. I don't know. I've never seen that sort of situation happen. I just think that the words of the statute would take precedence over an order of the
Regardless of
court,
what the
not based
people
on
do.
incomplete records.
Regardless of what the people do. You're just saying he's a mandatory, the statute says so. We couldn't have, the people didn't have to file anything.
Yeah, I mean, like, unfortunately, we didn't fully comply with the statute here. Nobody's saying that. We should have filed the writing, should have filed the city time. When that information comes before the court, though, court can't just ignore it. There was a broad remittal for resentencing here. That's all we had. We didn't have a specific remittal until Kaval 2. We had a broad remittal. Under that broad remittal for, quote, just a resentencing, the court was allowed to sentence Mr. Kaval as a persistent violent felony offender.
Thank you, counsel.
Thank you.
Good afternoon, Simon Greenberg for Respondent Rudolph Kaval.
Was it sent back, when it was sent back for sentencing, is it a de novo proceeding that takes place?
It is not a de novo proceeding, Your Honor. In this case, the people conceded that they had not, well, the people in fact did not meet their burden on the tolling issue, and they conceded it, and in Kaval 2, the appellate division interprets its prior decision as saying, we decided this issue and sent it back.
So when it went back, the people weren't required to present to the court information regarding the defendant's status so that he could receive a legal sentence?
They were not required to do so, and in fact, they were not permitted to do so because...
So the statute is permissive, is what you're arguing?
The statute is not permissive, Your Honor. However, litigation on even a mandatory issue an issue that has to be litigated has to end at some point. And here,
So it's a mandatory statute, but because of the way the case went up, the unique circumstances of this case, the people should not be permitted to offer information, valid or otherwise, that the defendant was a proper persistent felony offender.
it was mandatory that the people file the predicate felony statement at the original sentencing and that they prepare for a hearing on the issue as the judge...
But not when it went back?
When it went back, the appellate division had decided this issue and taken it off the table. And at that point, the people...
Well, based on the record the AD had in front of it. So that was my point to your adversary. Question is whether or not they go back and say, we want to create a different record.
Not if they cannot ask to make a different record in front of the resentencing judge once they've conceded that they failed to meet their burden and this issue has been decided by the appellate division.
If that's the case, why was it that your client, and I think this is what happened, at the resentencing made a request for consideration of his exemplary behavior? If it's not a new proceeding, all we really have to do is recalculate the sentence. Now you're introducing new elements into the sentencing determination. Why can't the people?
The distinction, Your Honor, is that Mr. Kaval never had an opportunity to present this evidence at the original sentencing because the evidence of his rehabilitation obviously did not exist at that point. And also, the judge at the resentencing still had to make a determination of the appropriate sentence within the range that was legal, which...
So the defendant could present information because he was being sentenced anew, but the people could not? Is that what you're arguing?
I'm arguing that the defendant could present information about his rehabilitation to aid the judge in coming to the judge's decision about where in the, for example, second violent felony offender sentencing range the sentence should fall. But that doesn't mean the people can bring in new information to relitigate an issue that has already been decided by the appellate division.
Could the people have brought in evidence that the prisoner had misbehaved?
They could have, yes, Your Honor, and this court's decisions say that the people, For example, the case law on vindictive sentencing allows on a if a defendant wins on an appeal and the case, the conviction gets overturned and then ultimately the defendant gets convicted and sentenced again, the people can ask the judge at the second sentencing to impose a higher sentence than the first time around, specifically based on post-sentencing misconduct. And so, yes, it's definitely something that people could have done. They could have asked for a higher sentence.
That's a whole different conviction, though, in that circumstance.
That's true, Your Honor.
Okay.
But the people.
Is
Counsel,
it-
can I
isn't the
ask you a
point, oh,
question?
sorry. Go ahead.
It seems like, I have a hard time with the law of the case idea here, but it seems like your argument is, it goes case by case, and you look at what the appellate division did in each case, and your view of this record is the appellate division ruling combined with the people's argument in this appeal precluded this evidence from going in at the resentencing. It's not a general rule. It's a case-by-case appellate division argument rule.
That's correct, Your Honor. In this case, the appellate division conclusively decided the question of whether the 1987 case was a valid predicate based on the people failing to meet their burden.
And it clearly, the appellate division could have done, I think, what Judge Wilson proposed before in his hypothetical, which is you have to go back and sentence as X, right? They could have done that, and that would have been an order to the court, but they didn't do, and they've done that, something like that, I think, in some of the other cases I've seen, but they didn't do that here. So does that go the other way then?
It does not, Your Honor. And yes, the appellate division could do that, but here there was, the people had not made a request to seek to relitigate the tolling issue about whether my client was a persistent. They conceded it, and they basically represented to the appellate division, I think pretty clearly, that they were not going to try to relitigate this issue because they said we're going to seek discretionary, specifically because discretionary persistent felony offender sentencing does not require us to present any evidence of tolling.
So Judge Garcia has carried out my hypothetical exactly where I wanted to go, which is the appellate division on the first appeal didn't issue a directive as clear as the one I gave in my hypothetical. But when it came up the second time, the appellate division interpreted its first decision as if it were that clear. What is our review of that?
I think that, I think there's federal case law saying that higher courts will give deference to a lower court in interpreting its own prior mandate and the meaning of its prior decisions. But
Is there a
and I
standard
think
of
that's an
review for that,
appropriate rule, Your
counsel?
Honor. I apologize.
Is there a standard of review for that kind of analysis? And under what standard do we defer to their interpretation?
I think, I don't know if I would call it abusive discretion, but some level of deference, given that the court has, better knowledge, for example, of its own internal processes about how a particular decision was
It's a
made.
bit odd here because the dissenter is the only person who was on that first panel.
That's true. Judge Dillon was on the first panel
I
and
mean,
no one else was.
Yeah, it's pretty hard to work that one through.
Would you agree, Counselor, in fact, that the defendant is a mandatory persistent felon?
No, Your Honor.
Why not?
Because the statute and the law require the people to meet a burden, and they didn't meet their burden.
All right, I
And-
think that's where I'm having some issue, right? Because there should be a right answer here. This isn't a concept that's amorphous. There's a number, and we can calculate that number. And if we calculate that number, there should only be one right answer. And if he is a mandatory persistent felon, which it appears he is, if we adopt your position, are we sanctioning an illegal sentence?
No, Your Honor, because what was actually illegal was, once the people failed to meet their burden at the sentencing, it was actually illegal to make my client a persistent because the
Did your
legality.
client challenge what was being offered?
My client, at the beginning of the sentencing, specifically controverted the tolling, which was, and the judge had directed the people several weeks before to prepare their paperwork for a hearing on the persistent violent issue. So the people had full notice and they filed their predicate felony statement 16 months before the sentencing. So they had months and months and months to ask the New York City Department of Correction for a simple document, and instead it took them, 6 years after they filed their predicate felony statement to finally go out and
I don't think
get
there's any way
it.
to read the record other than what you suggest, which is they failed. That's what the AD said, that's what they conceded to. The question is, can they, on the remand, get it right? That's the point. Can
Not-
they do that? Is there anything that forecloses them from, on the remand, getting it right?
There is the appellate division's decision conclusively deciding this issue and then accepting their representation, we're not going to try this again. And there's...
At the expense of an illegal sentence?
Well, it's not an illegal sentence,
Well, do
Your
you
Honor,
agree they
because of
could
the
have done
burden.
what they said, the example, we can ask for it discretionarily? You agree with that?
I'm sorry?
That they could have asked for it discretionarily?
Ask the appellate division?
No, on the remand. Do you agree with that? They
As
use
for
that as
what?
their example, that
They
on
could
remand.
have, yes, at the resentencing in 2019, the people could have asked the judge to impose a discretionary persistent sentence.
Then why not do it based on the actual record that shows the calculation, as Judge Singas has suggested?
I'm sorry, I don't think I understand. What do you, discretionary persistent
Yes.
sentencing, meaning under Penal Law 70.10, which does not require proof of tolling?
Correct.
They could have asked the resentencing judge to sentence my client as a discretionary persistent because that wouldn't require them to relitigate the tolling issue. But they could not ask they should not have been permitted based on the appellate division's.
But all I'm saying is if the court could have granted it without them having to meet the burden, once they're trying to meet the burden, and apparently do, why would the court be foreclosed from acting on the actual record?
Because litigation, Your Honor, has to come to an end at some point. That's a universal rule in our legal system.
Isn't the end after the resentencing?
I'm sorry?
Isn't it once you get through the resentencing?
Well, not,
I know you rely on Havelka, I understand the
Yeah.
argument, it's not one that's not, that it doesn't have any force to it, I understand, but I think we're stuck with the statute, and it's not so obvious that the AD isn't sending down a general de novo resentencing.
well, I mean, again, our position, as I've made clear, Your Honor, is that based on what happened in the appellate division, this issue was completely decided, and the people had a full and fair opportunity to litigate this issue at multiple stages, and they failed to meet their burden.
And counsel, that's really, to me, it seems like what the appellate division said the second time. It didn't say we ordered you the first time to sentence him as X. It said we decided this already, right? This is law of the case. You had a full and fair opportunity, you're done. It didn't say you violated our order, right? We ordered you to sentence this defendant as the other thing, right? It said we made this decision already.
They made a decision on this specific issue, which,
On the record, that was before them at the time, but they made the decision, right?
Well, the
And
record-
that was the basis of their decision the second time.
the basis of the decision the second time was that in order, that the appellate division on the second appeal had discretion to decide whether the people should be permitted to present this evidence that they knew all along they would need, and yet they took years to just simply ask the New York City Department of Correction to get it. So the second time around, the appellate division is saying, we're not going to reconsider our prior decision because of the people's failure to exercise any
But then
diligence.
isn't the real legal question to us whether or not they could create that record? The appellate division is wrong in saying that they couldn't do that.
Well, the issue is whether the appellate division could tell the people you can't make a new record. That is the issue. But I think, here the appellate division acted well within its authority to cut off further litigation. The people, there has to be some incentive for the people to be prepared for a hearing. And here, what happened is that years and years went by. Mr. Kaval still doesn't know what his sentence is going to be. And, that's prejudicial to him.
Isn't the incentive the statute? They look terrible because they didn't do what they needed to do. They failed to meet their burden, the loss of resources to their own office to continue to have to litigate this case. Isn't that incentive enough?
Well, that's some incentive, but I think there's
I
also...
could see if we're on the fourth round of this, right?
It is incentive that, obviously, their office needs to conserve their own resources, but there's also judicial resources that need to be conserved, and also there's the prejudice to Mr. Kaval going 9 years without knowing what his sentence is going to be,
But when Mr.
basically being
Kaval
in
came
limbo.
back, when he came back for resentencing, he was in a position to challenge their assertion with those new documents that he was a persistent, was he not?
Yes, he was, Your Honor.
Thank you, counsel.
Thank you. Well, for the reasons I've stated, Your Honor should affirm the reversal of the resentencing and also affirm the appellate division's instructions that Mr. Kaval be resentenced as a second violent felony offender. Thank you.
Thank you.
I think Your Honor said it best. If you affirm what the what the AD did here, you're basically sanctioning an illegal sentence.
But counsel, what about this one of the last points? I mean, what's the incentive then for your office to get this right the first time? Well, we'll try the state time. If the state time doesn't work and we lose on appeal, then we'll try the city time.
I mean, this is just about compliance with the statute.
No,
Like,
but
we always
I
look to get it
understand that,
right.
but we
the
have
first
to
time.
look at, what's going to happen the next time around. And I know, to me, it's a little distracting, one, the statute, and two, this law of the case. The real issue to me is, are you permitted to reopen this as a de novo hearing when it goes back? For that reason, that's the reason that I think pulls the other way, that what's the incentive for your office to get this right the first time?
I mean, there's really no incentive to not get it right, No one wants to do a sentencing a second time just to comply with a mandatory statutory duty. There's no incentive to keep this going. You want to get it over with, and it's really through pure inadvertence or oversight or whatever that this even happened in the first place. This isn't like an error that happens every day.
So it's the
Usually-
exception, what happened here, not the rule.
I'd say this case is quite exceptional, given the procedural path that it's followed. But I think when we
But
can...
it's not exceptional to have city time and state time, right?
No, I mean, just to see something bouncing back and forth the way this does through iterations of the appellate division decision, just for that reason. I've never seen a case like this. I don't think we ever will see a case like this again. But really, again, I'll end as I started. The easiest way, the easiest guidance for courts is to just follow the statute. The statute says must, and there are no exceptions. It doesn't say you don't get a second bite. It says must, end. And for those reasons, we ask that you reverse the appellate division's decision. Thank you
Thank you.
very much.